Good morning. I hope everybody's families are safe and secure. And if you live north of Marietta, I feel for you. My wife called and was 6 inches of snow and can't get out of the driveway. So, and we are one of the low spots up that way. Y'all bow with me. Gracious Heavenly Father, again we come asking you to forgive us of our sins, to say thank you for all the wonderful blessings you give to us, to ask, Lord, that you keep your hand on those that are under the snow watch. Keep them safe, secure. Let those that have to be on the roads travel without any problems. Lead and guide us. Be with us. Keep your hand on us. I ask these things in my Savior's name. Amen. Okay. Okay, Mr. Kidd.
Authority permits the president of GMC to appoint their designee, and also the president of Georgia College State University to appoint their designee as a member of the Greenway Authority. What the Greenway Authority is attached to the Department of Natural Resources for administrative purposes only. What it does is it develops some land along the Oconee River right outside of Milledgeville underneath the Oconee Bridge, developed it for use for fairs and parks and picnics and so forth and so on. A lot of Georgia College kids and a lot of GMC kids do all the work down there as far as cleaning it up, paving the sidewalks and so forth and so on.
Mr. Kidd, that authority is basically just in your county, right?
Yes, sir.
And it doesn't have any effect on any of those that are
no money, no effect. It just lets the two presidents appoint themselves or their designee to serve on that Greenway Authority.
Thank you. Any questions? Thank you. Mr. Atwood.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I bring for your favorable consideration House Bill 233. It's on the back page under the modified structure rule, about two-thirds of the way down. This is the culmination of hopefully a culmination of a 2.5-year effort started by my friend and Chairman Wendell Willard, and it's the Civil Forfeiture Reform Act. We've worked with a study committee. We've worked with many divergent groups to essentially deal with the civil forfeiture power of law enforcement to seize property believed to be connected with criminal activity. As many of you may know, it's come under, there's been some call for reform in recent years, and I'm happy to report to you that this bill does many, many things, but essentially what it does is bring some specific rules to what law enforcement and prosecutors can use forfeited assets for. It brings some better process for citizens to be sure that citizens' goods are not taken indiscriminately and that they have due process, and it provides reporting that must be done so that citizens will know what is being done with those assets. I'm happy to report to you that this bill has the support of the Prosecuting Attorneys Council, the Georgia Sheriff's Association, the police chiefs of Georgia, as well as certain other divergent groups such as the Institute for Justice and many other legal and civil liberties organizations. And with that, I'll be happy to, I can explain it in many, many hours of detail, or I can be quiet now, and I've learned to be quiet now. So I'll stand for questions.
I like quiet. Mr. Willard.
Thank you, Mr. Chairman. Is it true Representative, if we let this bill out, we'll lighten our load of this book by 111 pages.
I'm not sure that the representatives that represented the timber industry will be happy, but yes, sir, we will.
Is it not also further true that tomorrow I'm planning to file papers in the Brunswick Superior Court to change your name to Alex Solomon?
Well, thank you, sir.
If he had attorneys and sheriffs all working together, they had to all be under the influence of drugs or liquor. Thank you.
Peak, maybe, but I'm not going to say that.
Thank you.
Yes, sir. Thank you, Mr. Chairman. Thank you, ladies and gentlemen.
Mr. Caldwell.
Thank you, Mr. Chairman, members of the committee. I bring to you this morning House Bill 252, which is the fifth up from the bottom on page number 1. This is the J. Calvin Hill Jr. Act. It is a product of about 3 years of work that started with Chairman Hill, who was my former delegation chair. This is very simply 23 pages of repeal requested by various agencies and departments across the state. This passed unanimously out of the House last year. Got stalled up in the Senate, so we're just looking for an opportunity to put it back through the House again and send it back over to the Senate to tell us no on repeal again. So I'd be happy to yield for any questions, and I'd ask for your favorable consideration.
Anyone have questions? Thank you.
Thank you very much.
Ms. Quick.
Thank you, Mr. Chairman and members of the committee. I bring you House Bill 367, which is on page 2 and is the second up from your structured rule. This is brought on behalf of the judges of the Western Judicial Circuit and in accordance with the recommendation of the Judicial Council of Georgia. Judicial Council does a caseload assessment for Superior Court. The Western Circuit has been on their list for an additional judgeship, off and on since 2008, but significantly over the last years since 2011. 1 year, in fact, that workload assessment was almost 5 judges, and we have 3. And so this bill would create that 4th judgeship. It has been worked through the appropriations process. It is in the budget this morning. So I ask for your favorable consideration, but I yield for questions.
Any questions, Ms. Quick? Thank you.
Thank you, Mr. Chairman.
Mr. Spencer.
Thank you, Mr. Chairman. I'm asking for House Bill 69. It's the last bill on the front page under modified structure. It essentially allows it defines who the owner is of the data in these vehicle black boxes that have been mandated by the federal government. I have clarified concerns with Chairman Rogers, so I just wanted the committee to be aware of that. If you have any questions, I'll take them now.
No questions. Next bill. You got another one, don't you?
I do. Don't forget about House Bill 18, the jobs bill. Thank you.
Mr. Mitchell.
Thank you, Mr. Chairman. I once again call to your attention House Bill 115 under modified open rule. It simply allows some consumers to avoid foreclosure. This bill has been well vetted by the Judiciary Committee, and I need to remind this committee that they passed this bill in the previous session, and it went all the way through the House.
Any questions, Mr. Mitchell? Thank you. Mr. Reeves.
Thank you, Mr. Chairman.
Well, I'm glad to see you up here.
I'm sorry?
I'm glad to see you up here.
Glad to see you this morning, too. May it please the committee, I bring you House Bill 316. It's under the modified structure on the back page about halfway down. This bill allows ophthalmologists and optometrists to form a professional corporation together. I'm happy to take any questions.
Other than the fact that that's a real good bill, are there any questions? I don't hear any. It's amazing. Thank you.
Thank you, Mr. Chairman.
Mr. Carson.
Thank you, Mr. Chairman. Members of the committee, I bring before you House Bill 20, second page under structured rule. This is a tax bill that would allow Georgia entities, this is in regard to low-income housing tax credits, this would allow Georgia entities to allocate those tax credits within those limited partnerships regardless of the federal income tax treatment. This bill is exactly as written as House Bill 683, which passed with 160 plus votes in last session and was stalled in the Senate.
Questions, Mr. Carson? No questions. Thank you. Mr. Donahue.
Thank you, Mr. Chairman. Ladies and gentlemen.
I didn't think I'd hear from you again until we came up with something about wild pigs.
Can I stick around and do that one after this, sir?
I don't know if I want you to stick around after what you did for me and Rocky Raccoon.
I do bring before you HB 299, modified structure. It's on the back page, HB 299. This is called a convenience fee, and why this law is needed. Some merchants are already permitted to charge this fee. However, under the GILA Act, it is not permitted. This will allow those businesses to pass on this convenience fee to the customers who choose to pay his or her loan with a debit card or credit card or electronic means. Insurance Commissioner also asked that this be put in there just for basically their protection. We already do it in the state of Georgia.
Did you throw that last bit in so Richard and I could read the bill?
Yes, sir.
Do you have a clue what I'm talking about?
I do.
Okay.
I actually do. Yes, sir.
Any questions of Mr. Donahue on 299? Thank you. Wait a second. Back up. Please.
Thank you. I'm sorry, I wanted to get clarity about the definition of the term convenience fee. If I'm going to use a credit card and there is a charge made by the bank that is placed on the transaction and paid normally by the merchant, is that the convenience fee we're talking about?
Yes, sir. If you make pretty much a charge with your debit card and you call in, just to use that for an example, there's a 25-cent fee for that card. Used to, people mailed their checks in, they came by and would pay with cash. On a loan, these loans usually run anywhere from $40 to about $70 a month. That fee of a quarter, they're allowed, not by law now, to collect. We can do this throughout in other cases, but they are not. They are heavily guarded pretty much on what they can do.
Further question, Mr.
Yes,
Donahue. How do we know what the fee is going to be if we're not involved with the making of the contract or agreement between the merchant and that bank?
Yes, sir. Each card has a different, and I use this quite a bit. I own rental cabins. If I go VRBO, there's a stated fee of $3.275. There is a charge that we pass on to the customer at that time. If I'm with Square D, it's $3.225. There's a charge everybody knows. I cannot charge a penny more, and I don't charge a penny less. GILA has such regulations that it is difficult for them on contracts where it says no other fees to be charged. The insurance commissioner wanted to make sure we clarified that to where they could do what most of us already do in the state of Georgia.
Thank you, sir.
Yes, sir.
Mr. Williams.
Thank you, Mr. Chairman.
Yes, sir.
For clarification, at Kroger's, in my area,
yes, sir.
You make a purchase of gasoline,
yes, sir,
with a debit card,
yes, sir.
and you do it as a debit card. $1 shows up, regardless, excuse me, to the amount that you spend. You can spend $10. $1 is charged back by the bank. Speak to that now. You've built yours in on your cabins.
Yes, sir.
But how would this affect a $1 charge on a $10 purchase?
Basically, what happens with convenience stores and marts that sell gasoline, if you'll notice, a lot of them have a credit card price. That's the price they charge. They'll give you a cash discount price just because they would prefer you to pay with cash so they don't have to use that charge. It pretty much, what you're asking is, that's a charge that each company here has an opportunity to make. Some choose to use it, some choose not to use it, but it already is being used in the state of Georgia.
No more questions. Thank you.
Thank you.
Hang on. Mr. Lumsden.
Good morning, Mr. Chairman, members of the committee. I bring to you House Bill 99. This is on page 1 under Modified Open Rule. Item 3. Made this presentation to you earlier in the week. It simply creates a default condition of tenancy in common in certain divorce situations where property has not been disposed of otherwise. I would appreciate your favorable consideration, and I'll stand for any questions.
Any questions, Mr. Lumsden, on 99? Thank you. Next, have you got another bill, or you just want me to forget about it? I just forgot about it. You've got another bill. You don't have to ask for it. You've asked once, and it fell on deaf ears. But
all right, sir. Since I'm here, I will ask. But also on Modified Open Rule, page 1, last item, House Bill 338. This is a bill that was passed by the House last year, was held up on the rules side in the Senate because of its connection with the Technology Study Committee. They've indicated that they'd be willing to look at this again, but we've got to move it back through our side. So this is a bill that simply creates a local funding mechanism for electronic citations. Many good reasons why we want to do this, but that's the purpose of the bill, and I would certainly appreciate your favorable consideration for that one as well.
I would suggest that you take a long, hard look into the number of years you've got there for a sunset.
Yes, sir. I would be amenable to that. The reason for the sunset, though, is simply because our mid-sized and smaller counties do not generate the kind of revenue from this, and it may take them several years before they're able to accumulate enough to make the initial purchase of the system.
If this thing works right, the amount of time and effort that is saved should save them enough money to pay for whatever equipment that they get.
Yes, sir.
Thank you.
Thank you.
Ms. Beskin.
Thank you, Mr. Chairman and members of the committee. I'm here again today to ask for consideration of House Bill 297, which is number 3 under open rule on the first page. It provides that a state licensing board, a state professional licensing board may, but is not required, to contract with a National Association of State Boards to receive and process its examination applications. I can't think of anything especially funny or interesting to say about this bill, but I would ask for your
I don't mind funny. It's something interesting that I'm looking for about this bill.
So I would ask for the committee's favorable consideration on this bill.
Any questions of Ms. Beskin? Thank you.
Thank you.
Jay Shaw's little boy, Jason.
I've been called worse.
You sure have.
Yeah, I know it. Mr. Chairman and members of the committee, I bring to you House Bill 185 on page 1 under Modified Open Rule. This is a Department of Insurance bill. It's a model bill for them passed down from their association, the Insurance Commissioners Association. This bill will modify and more accurately gauge how much capital life insurance companies should hold in order to pay expected claims. Like I said, this will be a model bill that the rest of the country is adopting. It's very important to the department because it affects their certification with the NAIC. That's it.
Any questions, Mr. Shaw? No questions. Thank you. Mr. Hightower.
Thank you, Mr. Chairman. I bring to y'all HB 304 under modified open is second from last. This bill is a clarification bill. A couple of years when we were doing the criminal justice reform, there was a part in there that said that certain sentences had to have a probated, certain sentences had to have a period of time of probation. There was a court that interpreted that to mean that if you had two sentences running consecutive with each other, that the time of probation had to attach to each individual sentence, which would have worked out that in a sentence of, let's say, two 20-year sentences running consecutive each other, at the end of year 19, you'd have had to let a person out of jail for probation for a year, then rearrest them, put them back in jail for another 19 years, and then let them out for the final year of probation. This bill just goes to correct that and say, look, that never was the intent. The probated sentence should come at the end of the total sentence, so you're not letting anyone out. This has been given to the governor's office, make sure we're not messing anything up, but it is a clarification of that, and it's also supported by the Prosecutor's Attorney Council.
Any questions? No questions. Thank you, Mr. Hightower. Appreciate you showing up.
Thank you.
Mr. Belton.
Thank you, Mr. Chairman. To simplify, I'd like to bring to your attention the open rule number 4 is HB 103, Kelsey's Law. It basically says that you're not allowed to put a minor's personal information on a pornographic website. This happened to a young minor, 15-year-old girl named Kelsey Upton in my area. Her personal information, her phone number was put on a pornographic website through no fault of her own. Many teens commit suicide when something like this happens. She decided to fight it. This is the third year we've been trying to put this together. My first year, and I hope for your consideration. Thank you.
Also, the bill contains a non-merger of offenses clause.
I'm sorry, sir?
I'm just reading the note here. It says the bill contains a non-merger of offenses clause.
No, sir.
Put that down and think about that one.
Thanks, sir.
Thank you. Mr. Bruce.
Good morning, Mr. Chairman and members of the committee. I'm here to ask for House Bill 89, which changes a date in the code which would allow local governments to help combat drug and prostitution in their local communities. It's House Bill 89 under the modified open rules. Second.
Mr. Bruce has explained his bill on several times, so I don't think there's any questions. Thank you, Mr. Bruce.
Thank you.
Mr. Rutledge.
Thank you, Mr. Chairman, members of the committee. I have a couple of bills on the backside structured rule. HB 120, which will allow local counties to add state-owned properties to their T-SPLOS list if they so desire. That's the only change we're making to that.
Would you give me an example of that?
Technical college, training facility, state-owned training facility.
Okay. What's the other one?
HB 234 is a department bill, and it basically is pretty much saying what it's in the title. Whenever the Federal Reserve Bank is closed and a county office is open, they'll get it's basically the tax is not due until the Federal Reserve Bank is open.
Any questions? Thank you.
Thank you.
Mr. Petrie.
Thank you, Mr. Chairman. Committee, I'm here to speak to you on, again, on House Bill 340, Modified Structured Rule. As we discussed last time, and I think we had agreement, this was a bill that was passed last year, and we are trying to fix the language that was passed by the Senate and to allow us to, in a community where you have legalized Sunday sales, to allow bars to be open only on a St. Patrick's Day holiday. And we have fixed the language at the request of the chairman. Rather than saying an annual period of consecutive calendar days not exceeding 4 days, we now say 5 days, which allows us to use a Sunday on either side of the holiday regardless of when St. Pat's will fall on.
I get this done here in a day and a half. Anything else?
No, sir. I think that's all we've done here. I would just ask for your favorable consideration. My name is German, but there is a great deal of Irish blood in me, and with every ounce of it, I'd love to have you support.
Wait a second. Your name is what?
My name is German Petrie.
German. Oh, I thought you changed your last name. I thought.
No, sir. No, sir. No, sir.
Petrie.
I'm just emphasizing my Irish roots. Love to have your support, Mr. Chairman. That's right, Petrie.
Thank you.
Thank you, sir.
Mr. Jacobs, if I'd have seen you, you could have come to the front of the line.
Oh, I'm happy to wait on my colleagues, Mr. Chairman. Since I have 4 bills on the consideration calendar, I thought I'd try my luck asking for half of them. First is under Modified Structured Rule, House Bill 197. This is the bill that updates 3 uniform laws in the debtor-creditor area to make them consistent with the most current versions of these laws that are being adopted in the states.
Any questions? We got questions of the leader.
Thank you, Mr. Chairman. Chairman Jacobs, this wouldn't require the United States to recognize, for our purposes, laws of other nations, would it? I mean, this couldn't lead to something that would effectively change our rule of law?
No, because I suppose you're talking primarily about the Uniform Enforcement of Foreign Country Money Judgments Act. Georgia already has that adopted. This just clarifies the procedures, and that's it.
But we haven't adopted in the sense that we apply Georgia law to those situations, right? I mean, or do we adopt it in the sense that we accept?
Well, you would. The court inquires into whether due process, whether someone was served, and whether the procedures for due process are the same in the foreign country as exist here. But the reality is that we already have that uniform law adopted in Georgia. We're just clarifying it to make it consistent with the most up-to-date version of that Uniform Act. It exists already on the books.
One follow-up. I'm a little more confused. If we already have it, why do we need it here?
Because periodically the Uniform Law Commission, and I replaced Representative Lindsay as one of Georgia's Uniform Law Commissioners. Periodically, they go and update each of the uniform acts that are adopted in many of the states. And so this is just to make the current law consistent with the update to this Uniform Act that was adopted back in 2005, 2006 by the Uniform Law Commission. This particular statutory scheme, though, has been on the books for decades in Georgia.
Ms. Jones.
Thank you. Chairman Jacobs, I believe what the majority leader is looking for is just a simple no.
No.
Thank you. It will not authorize foreign laws to take primacy in Georgia.
Correct.
Madam Pro Tem, ask your question again.
Yeah. Believe the correct answer to
we can't hear. Wait a second. Nobody can hear that one. Try it again.
Got it on. I believe the correct
there you go.
Answer to whether or not this legislation would authorize the primacy of foreign law over domestic or Georgia law, the simple answer is no.
That's correct.
Any other questions? Next one.
And the other one, because again, all of the members of the DeKalb legislative delegation are on the same page about this one, is House Bill 215 under the structured rule. It only affects DeKalb County. I want to underscore that.
Any questions? Thank you.
Thank you, Mr. Chairman.
Mr. Benton.
House Bill 51. Oh, that's good.
We can cut it down a little bit now.
Do I need to explain that again, sir, or?
I think that the questions we had have been answered to.
Okay. Mr. Benton provided a case and a code section, and I believe what he's trying to do makes sense and clarifies a court case that was reached in 2005. Thank you for providing the information, Chairman.
Mr. Setzler.
Thank you, Mr. Chairman. Regarding HB 103, I've talked to the author, Representative Belton, and I'd like to make a motion to move that back to non-civil judiciary. We've got a hearing this afternoon, and we could perhaps address some of the concerns. HB 103.
We've got a motion. Is there any opposition to to go back? Ms. Cooper.
Thank you, Mr. Chairman. On page 2, I would like to ask for House Bill 195, that's the biosimilar bill, and also House Bill 394, that's the Georgia Board of Nursing revision. We clarified some things that were left off for last year. There's also a provision for dealing with foreign graduates. Like all areas of the medical profession, we occasionally have people come from other countries all over the world, and there is a accrediting agency that the board uses that looks at all these schools for nursing, and they have to be at least equal or better than the ones we have here in the state before they're allowed to go forward with applying for a license. And also, I made very sure that they have to speak, write, and understand English is part of that correction. I'll be glad to answer any questions.
Any questions of Ms. Cooper? No more questions. Mr. Knight.
Thank you, Mr. Chair. I'd like to ask for House Bill 183. It's on your second page, dealing with the Home Care Patient Protection Act. This bill seeks to strengthen the private care home care provider license to better protect the aging consumer by eliminating the option that these agencies, licensed agencies, are going out and contracting rather than employing non-skilled workers. And it's a very important change that will make sure that these unskilled workers going into people's homes are supervised properly by a nurse.
Any questions of Mr. Knight? Ms. Abrams?
Thank you, Mr. Chairman. Chairman Knight, looking on line 16, is sitter a defined term?
Yes, the companion and sitter task are up under this license part of this code, and this again only applies to the home care licensed private home care licensed agencies.
But they are defined?
Yes.
Okay,
yes.
Okay. Ms. Cooper, yours.
Mr. Chairman, may I make a statement about this bill? Not a question. 183 is really important. Elder abuse, both financially and physically, is rampant in our state, and a lot of it is from people just hiring people off the street and then allowing them to go into people's very vulnerable citizens' home. And this would put a stop to that in a large proponent. It still allows individuals to, if I go out and hire somebody to take care of somebody in my family and I'm willing to take that risk, you can still do it. But if you go to an agency, they have to have standards, and this is really important.
Anyone else? Mr. Hamilton.
Thank you, Mr. Chairman. House Bill 194.
The majority leader.
I move that we move House Bill 123 back to the Committee of Motor Vehicles for some corrective action there.
Any opposition? Okay, it's back, or going back. Nobody else wants anything? I'll set it with what we got. I guess it's time to go to work. Structured rule, back page. This is the calendar for Monday, HB 234. Any opposition? It's on. Modified structure, HB 394. Any opposition? Modified structure, HB 340. Any opposition? Modified structure, a real good bill, HB 316. Modified structure, HB 233. Any opposition? Modified structure, HB 197. Any opposition? Modified structure, HB 183. I beg your pardon? One 183 is what you're asking. 1 day, all right, 1 day hold on 183. Modified open, HB 51. 51. Any opposition? Modified open, HB 99. Any opposition? Modified open, HB 185. Any opposition? Modified structure, HB 18. Any opposition? That's it.